Writs are the integral and substantial parts of judicial review, and these writs are issued by the apex court or the highest court or the higher court of the land in case there is violation or infringement of any fundamental rights or for enforcement of those fundamental rights which falls under part 3 of the constitution. So writs are considered as protector and guarantor of those fundamental rights. So whenever anyone's fundamental rights is threatened to be violated, or if there is any imminent danger of infringement, then writs can be issued. And regarding that, there must be some prima facie case behind a writ petition. So, regarding that, we can discuss certain leading cases like the MC Mehta case of 1987 and the very important leading case Rudal Singh versus State of Bihar in 1983, where 14 years were spent in the custody of the jail even after acquittal abated by the trial court. So, Supreme Court on that writ petition awarded a compensation of rupees 30,000 to the petitioner. And so another important leading case that is relating to DC Wada versus State of Bihar in 1987, where there was the main petition on repeated issue of ordinances, and as regarding the very application of res judicata in case of filing writ petition, we can mention the important case of Trilok Chand versus K.B. Munshi in 1970, and also under Article 226 Ghulam Sarwar versus Union of India 1967 regarding a petition of habeas corpus. So, in that case, the court expressed that to admit or to reject on res judicata, it purely under court's discretion. And also in Cecil D. Souza case in 1957, there was a writ petition on the basis of senior list regarding promotion of the 1956 batch. So in Amritlal case of 1975 regarding promotion, and in another leading case, that is G.P. Duval's case in 1984, where repeated representation were made by the petitioner. So, also on malicious or ill-motivated writ petitions, as it was expressed by the apex court by rejecting such malicious or ill-motivated writ petitions in the leading case Kinney versus Union of India in 1985. So also petitions, writ petitions on misrepresentation or suppression of facts as it was expressed by the apex court by rejecting such petitions in the very important leading case, Welcome Hotel case in 1983. So also, the apex court expressed displeasure regarding infructuous petitions or fruitless petitions filed as it was expressed in Mohit's case in 1976 and regarding any writ petition filed even having existence of adequate alternative remedy, the apex court did not entertain such writ petition as it was expressed in Trilogian case in 1969 and regarding who may apply for a writ petition. So, any ordinary person and regarding Article 19, only the citizens they are eligible to file a writ petition on the violation and infringement of those fundamental rights embodied under Article 19. So also a company has under Article 14, so also the non-citizens. But there must be prima facie case. But regarding habeas corpus, any person can file a writ petition but not by an absolute stranger as it was expressed by the apex court in Sharanjit Lal case in 1951 and regarding PIL, public interest litigation, the apex court expressed that there must be bona fide intention and the very question of inability of the writ petitioner due to poverty, disability, socially or economically disadvantaged sections or position of such persons. In that case, an PIL could be filed as expressed by the apex court, and regarding such, there must be the discussion of such certain leading cases like the Bandhu Mukti Morcha, which was unbonded labor, and S.P. Gupta case in 1982, and regarding another one, the Fertilizer Corporation of Union 1981, so also Hussainara Khatun's case of 1979 regarding release of under trials, and so also M.C. Mehta case in 1987 relating to pollution due to fertilizer industries. So also M.C. Mehta's case in 1988 regarding pollution of river Ganga. So also M.C. Mehta's 1992 PIL relating to environmental study, and where it was decided that environmental study as a compulsory subject and the very spread of information through audio visual media is the work of the government to make vigilant the people regarding environmental pollution, and as regarding the very concept public interest litigation as it was developed in India, the very fathers of public interest litigation in India as reads will go to the credit of Justice Krishna Iyer and Justice P.N. Bhagavati, who started the very contention of public interest litigation at the very beginning of 1976, which foundation was led by Justice Krishna Iyer, and it was further developed and grew due to the attempts and the sincerity endeavor taken by Justice P.N. Bhagavati. So, in our next video, we'll discuss in detail about all those writs like habeas corpus, mandamus, certiorari, quo warranto, and prohibition in detail.